We now turn to the next case on this morning's docket. That is case number 107180, State of Kansas v. Coons. Council, give us about 15 seconds to get settled.
Oh, yeah, absolutely.
You may proceed.
Thank you. May it please the court, Joanna Labastida of the Kansas Appellate Defender Office for the appellant, Mr. Olin Coons. If I may, I'd like to reserve 3 minutes rebuttal, please.
3 minutes is granted.
Thank you. And unless this court would prefer otherwise, I'd like to focus on issue 1. Issue 1 was a motion for new trial, primarily based on the ineffective assistance of counsel of Mr. Coons' trial attorney. And as this court knows, in order to be successful on a claim of IAC, Mr. Coons must show that his trial counsel's representation fell below an objective standard of reasonableness and undermine the Sixth Amendment right to effective counsel. Additionally, Mr. Coons must show that there was a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. And a reasonable probability is a probability sufficient to undermine confidence in the outcome. I'd like to focus on the first part of that issue that his motion for new trial dealt with, his trial attorney's failure to object to statements by the victim to her mother based on the confrontation clause. This court has held that when a statement is testimonial, it must be excluded unless a court finds that the declarant is unavailable and as a witness and that the defendant had a prior opportunity to cross-examine the declarant.
How is a statement one makes to your mother in almost any circumstance testimonial?
I think in this particular circumstance, it was testimonial. Normally, I would say, yes, you're right, probably not testimonial. But in this particular circumstance, it was testimonial because she specifically said that he has covered his tracks so no one will be able to find out who did it. And so I think that statement, and I'm paraphrasing, I can get the exact quote, that statement leads it to be testimonial in that she wants him to be caught and she wants someone to have the information that he's the one that killed her.
If
and her
so,
husband.
why didn't she call 911 and tell them?
I don't know.
I mean, one of our factors, we apply an objective test, and one of our factors was a statement made to a government official.
I think, well, the case law that I reviewed doesn't always have to be to a government official. It just
It's always, but it's a factor.
Right, exactly. And I think that if she had called the police, that would have been in the context of getting emergency assistance. In this circumstance, it was just the primary purpose of that was to prove relevant information later, that Mr. Coons was the one she claims that was there to kill her and her husband. That is the sticking point, whether or not it was testimonial. That's my argument for whether it was. The problem for the motion for new trial was that his attorney did not object to that testimony at all. She challenged it pre-trial, but on other grounds that were not successful, and she didn't object at all to preserve it for appeal. Another troubling circumstance with the motion for new trial is that the district court was under the mistaken belief that this court would still review that evidence even without an objection. So it was kind of a two-layer mistakes, basically faults. First, trial counsel didn't object, didn't preserve anything for appeal on that statement. Basically the only evidence linking Mr. Coons to the crime. And then the district court was mistaken on the law, whether or not this court would review that, because in his words, it was such important evidence that of course this court would review it. So basically, Mr. Coons' right to a fair trial was violated. The state argues that Mr. Coons forfeited his right to challenge that by forfeiture by wrongdoing, basically. We would argue that that does not apply in this case because the state didn't prove by a preponderance of the evidence that the defendant's act was specifically intended to prevent her testimony. And I think probably the best circumstance shows that their jailhouse snitch testified that to Mr. Coons said that he didn't understand how they came to get him so quickly. So in my mind, that shows that Mr. Coons didn't even know that the victim had called anyone. Otherwise, that would be a pretty good indicator of how they arrested him so quickly. So I don't think you can have it both ways, that have that testimony at trial and then later argue that he forfeited by an act of wrongdoing his right to challenge that.
I'm not following the logic of that.
Well, first of all, I don't think that the state proved by preponderance of the evidence that his act was for the specific intent to prevent someone from testifying at trial.
I got that part.
Right.
It was what you said after that.
The jailhouse snitch, his name was Rupert, I believe, first name, I'm not sure, testified that Mr. Coons had told him that he was, his mind was racing, he didn't understand how they got to him so quickly, the police, how they were able to arrest him so quickly. And so, in my mind, that means that he didn't even know Kathleen had called anyone, that he didn't understand how there was any evidence against him. So if you see your intended victim on the phone with someone, that might be a good indication that she's calling someone for help, and yet another indication that the police might get involved soon. And so the snitch's testimony that Mr. Coons didn't even understand why he was arrested so quickly would be a good indicator that he didn't know that that testimony was out there, that victim's testimony would be out there. I hope I made myself clear.
The victim's statement through another witness.
Yes, exactly. I'm sorry. The victim's statement. I think that the district court, in making its findings, it had intended to potentially hold another hearing on the second prong of the Strickland factors. But in its findings, it made several comments as to the prejudice to Mr. Coons and the evidence that presented at trial, how the district court itself would not have been surprised if Mr. Coons had been acquitted because there was so little evidence tying him to the crime. The only actual evidence tying him to the crime was the statement by the victim to her mother that was not objected to by trial counsel. There was no forensic evidence. He had an alibi. Several people at his home testified that he was home. His daughter said that she saw him get up to use the bathroom at 2:30 in the morning. They were staying up watching movies. And around the time of the murder. So really, the only incriminating evidence was this statement by the victim to her mother. And the defense attorney's failure to object to that fell below a reasonable standard of representation.
You've spent all your time on most of your time.
Yes.
On the confrontation clause issue. I want to ask about the crime scene video because you've said something in your brief that I don't understand. In regard to that, you say that the district court erroneously held that Kalb had shown the video to the defense expert witness. And when I went and looked at the trial court's ruling, it says, I don't believe that her not showing it to him constituted ineffective assistance of counsel. Now that says to me that the court did not make the finding that you represent in your brief. So where do you come up with it?
Let's see. I might have to look at the transcript while my colleague is arguing, if you don't mind.
I think the best you can do is a statement, one sentence up, a couple sentences up from that says, as I say, her recollection is that she shared it with the expert. But when you look at the sentences before that, where the court's ruling, the court is making clear that the expert and defense counsel knew of the existence of the crime video, had even gone to take the photographs and went back to the crime scene and used the photographs to do a blood splatter deal, so I think the word shared it clearly means in this context that it was about the fact that they knew it existed, not that they had shown it. But when you get a chance, if there's something else in this record that
I will.
makes me, that would justify that statement, let me know.
I definitely will. And I hope that I didn't misinterpret his statements to mean that something that wasn't true. So I apologize for that. And I will look at the transcript while my colleague is arguing. There are several other issues raised in the brief, and I'm happy to answer any questions related to those. My time is slowly dwindling down, so
You have no further presentation for us?
at this point, no, Your
All
Honor.
right. Do we have any more questions? Thank you, counsel.
Thank you.
Good morning, Your Honors. I'm Ed Brandcart, Chief Deputy District Attorney for the state. I think I should probably acknowledge the last issue. I was here and argued Molina and briefed that case. I didn't try Molina, but certainly was involved in some of the consultations as several prosecutors' offices made the arguments about the Hard 50. And I can't imagine, given the development since we filed the briefs in these cases, that that last issue would survive. We anticipate that you're going to say that that needs to be, or Judge McNally's Hard 50 sentence does not comport with the rules, so there'll have to be another sentencing on that, or unless you modify it to life with the Hard 25. Your Honors, our brief refers to specific facts about all the things that trial counsel did. And we, of course, want to draw back and have you look at the whole representation instead of a couple of specific points that are the subject of criticism.
Counsel, I'm sorry to interrupt you.
Yes, sir.
But I want to go back to the Hard 50 for
Yes,
a
sir.
second. One of the findings by the district court that justified the Hard 50, I mean, I understand the jury trial question, but I'm not
Yes.
asking about that, was the heinous nature of this crime. And I'm having difficulty separating out murder from a heinous murder. And it just, I mean, clearly all murders can't fall under this, can they? So that heinous has got to mean something else. And I'm trying to figure out how this particular crime qualifies for being heinous.
Yes, sir. I think it's the fact that Kathleen Schroll was made to know her fate. If what she was told by the defendant before he went into the bedroom to kill her husband, and then it came to pass with her, she was told, "I'm going to kill your husband. I'm going to come back. I'm going to kill you. Nobody's going to know it was me." It's that taunting that let her know her fate. That I think there is some examples in the case law about that being an example of heinousness. It's not the gunshot wound, although it was right up against her head and just practically exploded her head. But I think it's that, Judge.
Okay. Thank you.
You're returning to the IAC claim?
Yes, sir. We were, I was asking you to look at the whole representation. I think it's just so important in this case to summarize that his trial attorney, Patty Kalb, presented a case with an alibi defense, deliberately chose to have in the first trial an all or nothing. It was either alibi or it was premeditated first-degree murder. And her argument succeeded in acquitting him of one of two counts of murder. And under these circumstances, I would hope that there's some head scratching about that. There certainly was in the courtroom. I've talked to some jurors afterwards and know the result of that. But then, not only did she succeed in having one count acquitted, but she succeeded in having a new trial on the remaining one and tried it again. And both trials lasted a number of days, lots of witnesses. She incorporated experts. She has, I think that most of the complaints about her performance, as I've written in our brief, are that not that she didn't do something, but that she didn't do something well or didn't do it enough. Because she did engage an expert on a variety of topics, not all of which made it in the brief. She engaged an expert on computer technology. She consulted with experts about some other things, used the one expert, Mr. Geidson. But the complaint is that she didn't go far enough in those things. And I think that's particularly telling that this was a trial attorney who was engaged, who participated from start to finish, examined evidence, consulted with the client, tried the case twice on the same theory of alibi. Certainly there was consultation with the defendant at that point. He'd seen it happen all one time before. There just is no indication that the whole representation fell below an objective standard. The defense expert on post-trial was an attorney from Olathe. He's come here many times and offered his opinion with 20/20 hindsight as to some of the things he might have done. But certainly on cross-examination then acknowledged that he had signed on as one of the defense lawyers hoping to overturn the conviction. And my point to the sentencing court was that was obviously a biased interpretation and very difficult to call it an objective standard at that point. Or the standard was there, but the evidence in support of it wasn't objective.
Are you suggesting that he didn't make the requisite opinion statement that to satisfy the first prong of the Strickland test?
No, ma'am.
Okay.
No. Judge McNally, he reflected carefully on not just the last trial, but all the representation, both trials. And it was a challenge. We're all humans in addition to being lawyers. It's my recollection that all the motions that were tried and objections that were raised in the first trial were raised again in the second trial. The record is a little bit thin on just when Patty Kalb may have objected to the introduction of some evidence. Certainly everybody in that room thought it was objected to. We have. The judge did. I think the only person who claims that she didn't make that objection, I mean, I'm not trying to challenge the black and white of the transcript, but it's really only the defendant who says that that wasn't challenged or wasn't appropriately preserved for appeal. We certainly thought it was.
Why did you think that?
Quite honestly, Judge, it's because of the series of objections.
But this court has said it doesn't matter if everyone in the courtroom knows what the judge is going to rule and everyone knows the objection. It nevertheless has to be made contemporaneous with the question.
I understand. And I believe Judge McNally acknowledged that it hadn't. And his finding, having watched the proceedings twice, was that it was merely an oversight.
But isn't that a matter of competence? And that's what we're talking about, is that defense counsel should know what's necessary to preserve the issue.
I'm glad you asked.
And if they drop the ball, then hasn't met the first prong.
I'm glad you asked, Your Honor. There's nothing here to indicate that Ms. Kalb wasn't competent or didn't know that she should object. She had before. That was a human failure. And it was one thing in the context of an otherwise lengthy trial with a broad variety of results that are clearly Ms. Kalb's achievements as a defense counsel in this case. Our brief sets out all of our arguments. I certainly submit it. Unless there are additional questions, I'm asking the court to affirm the conviction, and we understand there will be some additional sentencing order.
Any more questions? Thank you, counsel. You reserve 3 minutes for both.
First of all, to answer Justice Biles' question about the district court's findings, I guess I understood the phrase, "as I say, her recollection is that she shared it with the expert," to mean that he was holding that she hadn't shared it with the expert.
Would you agree the next sentence after that that says she didn't show it, so that's not ineffective, that the district,
Yeah.
that we can take off the table the idea that the district court's ruling was not supported by substantial competent evidence?
I suppose I took that last statement of, I don't believe her not showing it to him constituted IAC, was basically like, even if she didn't show it to him, it still was an IAC. But
Doesn't say even if, though. I think, do you want to stick with the argument or not? And we'll
Well,
rule on it. I'm just trying to figure out if it's in play.
I suppose my reading of it may have not quite been as concrete as what this court would interpret it, but, and I apologize if I might have been overstepping what he was saying, but my argument was that he held that she had showed it to him. Just to go back to the defense attorney's failure to object, it wasn't just that she failed to preserve an issue for appeal. In her testimony, she had a misunderstanding of how the confrontation clause worked, and she did not understand that this statement might have been inadmissible based on the confrontation clause, and she failed to object on that standard as well, or on that level as well. On top of that, the district court was misinformed as to how this court finds that issues are reserved for appeal. So several mistakes with that first subsection of the issue.
Any further presentation?
No, Your Honor.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.